All right. Hey, Tracy, can you hear me?
I can hear you.
All righty. We shall go on the record with proceeding number 24A-0446CP-EXT in the matter of the application of Tava Cab, I hope I'm pronouncing that correctly, LLC, doing a business as Tava Cab to extend operations under Certificate of Public Convenience and Necessity number 55994. Administrative Law Judge Robert Garvey. Today is the 21st of January, 2025, approximately 11 a.m. This proceeding comes on for a pre-hearing conference, and I will start with appearances, and I'll start with the applicant. Yes, Mr. Burr, I'm going to have you turn on your. Can't hear you.
How's that?
That's much better.
All right. Good morning, Your Honor. My name is Richard Barra, B as in boy, ARA, registration number 7886, telephone number 720-271-7272, 7828 Vance Drive, Suite 105, Arvada, Colorado, 80003, appearing here on behalf of the applicant, Tava Cab, LLC, DBA Tava Cab.
All right. And who do we have here for Pikes Peak?
Marcos Grego, Marcos part owner and representative for Pikes Peak Cab.
Okay, it's Greg. You pronounce that Grego?
Grego, yes.
Okay. All righty. Like I said, this is on for a pre-hearing conference. Before I even get into that stuff, I will just take notice that I have seen Mr. Grego, your what I'm just describing as a motion to dismiss. And Mr. Burr, I did see that you filed something this morning. And I've had time to look at that. I'm not going to rule on the motion today, since I just got it about an hour and a half ago, something like that. But I do have a couple questions about it, and going to get to that. I guess I'll get to that first. So real quickly in your response, Mr. Burr, you state that and is it Tava or Tava Cab?
Tava.
Tava Cab. Tava Cab seeks call and demand shuttle authority within El Paso County, not taxi authority. That's part of your argument, and based upon the motion dismissed. Now, and you say you look at the notice on there, and I had like 30 minutes to look through this, and I'm looking through all this stuff. What I have determined, at least in your initial application, it lists call and demand taxi service for the four different things. There's four different areas that you want the authority to be changed to. That all lists call and demand taxi service. Now in the notice, it actually changed the fourth one to call and demand shuttle service, which I believe was probably an error based upon what your application was. Now, being me, I just go to the notice when I set these things up, and I copy the notice and I put that in there. So my decision also said call and demand shuttle service. Now, based upon what you've stated there, I just want to make sure what service you're actually requesting for these four different areas. And
Let me explain.
Okay.
We originally filed with the taxi service, but that was before I recognized that El Paso County was one of the large market taxis. So then I talked it over with the staff, and if you look at the transcript of the proceedings, we had emails back and forth, and where I authorized them to change it from taxi to shuttle so that it would be in comport with the law. And so the notice is correct.
Well, but the notice, well, then the notice, the first three numbers there says call and demand taxi service, and the places in there, just looking at it, number one ends, this portion is said certificate. Okay, never mind. That one says restricted from any that originates in El Paso County. But it actually says between all points in one hand counties of El Paso for call and demand taxi service. Number two says call and demand taxi service from Colorado Springs Airport, which I gotta think is in El Paso County. Number three is call and demand taxi service, and lists some places all located in El Paso County. So should all of these say call and demand shuttle service?
Let me see what that says.
If you look on the notice, look at the fourth one.
Yeah, I got the notice.
Shuttle.
I got the notice in front of me. Part one, that's in and out of El Paso County. That's appropriate because the base of part one is Teller County. Part two is correct because that's from the Peterson Field in El Paso County, but it's going to Poynton Teller County, so that's correct. And three is from those communities of Cascade, Chapita Park, and Green Mountain Falls, all in El Paso County on the one hand, and all points in Teller County on the other. So again, it's in and out, so that's correct. And that's why four was changed, because four was the only one that was wholly within El Paso County. And that's why four was changed from call and man shuttle service.
Okay, all right, thank you, thank you. I just want to make sure, I want to make sure that I didn't have something wrong there and to know what I was looking at.
Notice is perfectly correct.
Okay, okay, thank you very much. Again, I'm not gonna rule on that today. I gotta look at it and see what we have there. But I just noticed that, and I just wanted to make sure that that I had that correct as to what that the authority was correct and I knew what you were asking for. Other than that, then I'm not saying, and Mr. Grego, what I'm going to do now, I'm going to set this for a procedural schedule right now. I might fine for you and dismiss this case, and if that will get rid of the procedural schedule. But since we're all here, let's get it all set up.
Sure.
Make sense? Okay. And so what we do, and Mr. Grego, I'll tell you real quickly, since you're representing yourself and you're representing your company, and you're not an attorney. If I start saying some stuff that's legalese that you don't understand, doesn't make sense, stop me. Make sure you understand what I'm talking about. Okay.
We got it.
I want to make sure that you understand what's going on. You understand the terms we're using. I'm not gonna worry if you don't use certain terms. Oh, Mr. Barr, I have to correct you on one thing. While I do appreciate the Gettysburg reference in your response, I do believe the Gettysburg Address was written on an envelope. So I don't really see the formatting. I don't see the formatting of the thing.
The way it looks, the way it was sent to me on my screen, it looks like it was written on an envelope.
Yeah. Okay. All right. Nice reference, but I didn't see how the envelope came
I
into
had
play.
saltier ones.
Right. But I apologize for not mentioning that earlier.
No problems.
But okay. So what we're going to do, and like I said, Mr. Grego, please stop me if I say anything that doesn't make sense. So I know you've done. I'm not sure how far. I know you've had a couple other proceedings that you've dealt with. They haven't been with me, with other judges, and I don't know how far you got into the procedural schedule. So this might be kind of a refresher for you. Did you get to the point of filing exhibits before, or did you settle before that?
We haven't filed any exhibits yet. We did request discovery from Mr. Barra, but he said he can't legally give them because it would be aiding and abetting unauthorized law practice by his part. We don't really have any way to submit anything at this point if he doesn't give us discovery.
Well, I'm just talking about. I'll get to that in a second. But I'm talking about the past cases. In the past cases that you had, did you get to the point of filing exhibits?
All the past cases with Tava Cab, she agreed to restrict her authority. We never had to go to trial.
Okay, but you didn't get to. Did you get to the level of filing exhibits?
No.
Okay.
I don't believe so. I'm pretty sure not.
Okay. I'm just asking just if you've done the process before you understand it. But so what I'm going to do is the first off, we're going to go to the applicant in this case. Mr. Barr, how about you get your witness list and exhibits and filed and served by the 21st of February. I'm making it a little bit further out since we have this pending motion that I'll try and issue out. So I'm making it a little further. How about, can you get it to me by then?
Let me look at my calendar, please.
Sure. I can't hear you. He's muted.
Okay, I said the 21st would be okay. But I also would like to point out that we have already filed a preliminary witness list and exhibits in accord with the notice provisions, which state that we're supposed to file them 10 days after it comes off notice. So we did that and timely filed it. And
That's fine.
I would point out that the intervener has not filed their witness list and exhibits, even though the notice says that they're supposed to. It says, if applicant has not filed its testimony or detailed summary of testimony and copies of exhibits with the application, which we didn't, each intervener shall serve and file its list of witnesses and copies of exhibits no later than 20 days after the notice period has expired. Well, they never did anything. We don't have anything from them.
Well, that's fine. I'm going to waive any rule. But we've got a pro se party on the other side, and I'll waive any requirement there. I'm also allowing you to revamp anything you want at that point until the 21st. And I'll let Mr. Grego do. And what I'm going to say, Mr. Grego, the 7th of March, can you get your witness list, the witness list and exhibits filed through the system, through the commission's filing and served on the applicant? That'll the order I issue will have different further requirements on and tell more that must be needed. But is that date? Do you think that date would work for you?
I think that date will work. I think kind of depending on if we can get discovery from Tava's attorney.
Yeah, I mean, he's been from my last order. Mr. Grego was allowed to represent the interests.
I recognize that, but he's not allowed to practice law. You can't authorize a non-lawyer to practice law. You don't have that power.
He can represent the interests of the company.
Yeah, but he can't file discovery. That's practicing law.
He can ask for discovery. He's not filing discovery. He's asking you for discovery.
I mean, I can send you a case that specifically says that discovery.
Hey, you're going in and out, Mr. Barra. You're muted again. You've accidentally muted yourself again.
How's that?
That's better.
All right, I'll put the mouse away. It's the mouse. Mice. I have a cat. I shouldn't have mice. But, what I was saying is that the act of serving discovery is the practice of law, and that's People versus Smith. And I sent Mr.
Barra, let me ask you this. Can a person in a criminal case represent himself?
Can rep himself, yes, of course.
Can he get discovery from the state in that case?
Because he's representing himself, of course.
And he is representing the party here. He can represent the party here. Under the law, he can represent the following the law we have. That's 3 owners. Amount in question is under $15,000. He can do that. That's been a long established practice of the commission. I granted he can get discovery. He can get discovery.
I will send you the case, Your Honor.
You can send me the case. I'm going to say no. I'll tell you that right now. I'm going to tell you no.
Well, it's the practice of law, and then you and I will be guilty of aiding and abetting.
Well, you know what? Then the John Law is going to come and arrest us both. Then,
no,
I don't think that's going to happen. I got to tell you what.
It's OARC that comes after us.
Well, I'm going to tell you, OARC is going to give the commission and every one of the judges and a lot of attorneys are going to be they're going to fill the jails with us. So I'm going to tell you, he's going to get it.
Well, I think that's unfair because he's supposed to be treated like anybody else. He's not supposed to get special treatment, and that's getting special.
Am I wrong? Am I wrong? Am I wrong in my ruling?
I believe you are, Your Honor.
Then you may take any necessary means that you think is correct. Okay. Judges are wrong sometimes. Please tell me I am.
Well, I don't want to, but I'm just telling you what the law is. I didn't
Well,
make the laws.
I appreciate you telling me what the law is. I'm telling you what the law is also. And I'm telling you what the practice of the commission has been. My first year here was 2012, and it's been that way since 2012. So I'm pretty darn sure of it.
Well, I've been practicing before the PUC, since my 33rd birthday, which was on May 10th, 1978.
And sometimes, Mr. Barr, people disagree in the law. I've heard of that happening before.
Yeah, I think that's why we have a Supreme Court.
Exactly. So if I'm wrong, you go tell the proper people I'm wrong.
Well, I will first send you a copy of the case that says that a lay person representing a third party cannot serve discovery if that
He's an
suppresses the
owner
law.
of the company. He's an owner of the company.
But it's an LLC.
He's always part of the LLC. I'm
If
just
it
telling you,
if
that's the
if it
practice.
was if it was a
You can send me the case all you want. Send me the case all you want. You're gonna lose. You're gonna lose today. Okay. 100%. Gonna lose.
okay, all right.
All right, Joe, we got Mr. Barrow, we got you getting that applicant or get the witness and exhibit list on the 21st of February. Mr. Grego, I got you for the 7th. Again, there'll be more on there and the decision that comes out that lists that. But if you file with the commission, they'll get served over to Mr. Barrow. If there's any problems with discovery, tell me about them. How about a hearing? I was thinking of hearing somewhere around the 18th of March. We can set it. I don't think it'll take how many witnesses do you think you're gonna have, Mr. Barr? I know you have the preliminary witness list in. How many of them?
Yeah, I had 10 on the witness list, so I would assume I'm going to have at least 20, but you just never know. It depends on the weather.
Well, no, it's not gonna depend on the weather. We'll do it remotely. That's why we don't have to worry about the weather. Unless you give me a good reason why we can't do it remotely.
No. My client would prefer a remote, but even
No,
with
we'll do it remote.
we're talking about Teller County, and I mean Teller County is the boonies. No offense
Yeah.
to Teller County, but
I don't live in Teller County, so no offense taken. But no, we'll do it remotely. Then I mean, March. I'm talking in March, and I'm not risking people trying to get downtown. People want this to be done, so we're gonna do it remote. I can do it. We can set it for 2 days for the 18th and the 19th.
okay.
Mr. Grego, I'll ask you real quickly. How many witnesses do you have? What would you think? Yeah, I'm not holding you to anything.
Right now, we have 15.
15. My God. Well, I'll tell you what. We'll set it for 2 days, and I might set it. Let me look at the calendar quickly. Actually, that could take a while. My goodness. I just want to make sure there's nothing big scheduled on the 20th. Starts there. Let's just say the 18th and the 19th now, and we'll work. If for some reason we go longer than that, excuse me, we'll work on that. But there'll be remote hearing just like this. And Mr. Grego, you seem to be doing fine on with Zoom. I'll put a little thing in there if you want.
That's fine.
Just for information, my legal assistant's on here right now, and what we'll do is the exhibits they'll be presented on the screen. She does it. You don't have to do it yourself. So if you file the exhibits, you'll say, "Hey, listen, could you bring up exhibit 101?" My legal assistant will do it. So you don't have to worry about that aspect.
Put everything in the box. Everything goes in the box. I think it's box.com. Yeah.
Right. So I just make sure you don't have to worry about that. I don't worry about that. They're very good. They do a wonderful job, and they make my life much easier. Okay. Anything more? I think that's it for right now. Do you have any questions, Mr. Gregory? So what you're going to do, I'll tell you real quickly for the hearing. So the burden is not going to be on you. It's going to be on Mr. Barra to win the case. So he has the burden in the case. It's by preponderance of the evidence, which just means a little bit more than 50% on the different things that are in question. He'll present his case. You'll have the opportunity to cross-examine his witnesses. All right. I'll tell you this one. If we go to a hearing, I'll tell you this then, but I'll tell you now. The cross-examination is not, hey, you know what I really want to tell you is this. There are questions to the person that's on the stand. So make sure they're aimed that direction.
Yes.
When you're done doing that, I might have questions for witnesses, and then Mr. Barr can do what we call a redirect. He'll go through all his witnesses, any exhibits that he presents. If you guys can stipulate to him, you don't have a problem, that's great. We can do that. We don't have to waste time. If not, he'll have to present them. He'll have to lay a foundation for them. He'll ask for them to be entered into the record. You at that point will have the opportunity to object to any exhibits that he might have. Here's one thing I'll tell you, I'm not going to hold you any magic words on anything when you do that. But your objection can't be, that really hurts my case. That doesn't help me. I don't like that. Those cannot be objections. But if Mr. Barr, who's telling me about how he turned 36 years old in 1978,
33, please. Don't
33. Sorry. If Mr. Barr shows us a picture from the first time that he appeared before the commission when he was 33 years old in 1978, and you
I
say,
looked exactly the same.
I assume you did. And you say, I have no idea why Mr. Barr is bringing this picture of him from 1978. It has nothing to do with what we're doing here today. I'm not going to hold you to the word relevance. I'll sustain your objection and I'll say, yeah, I agree with you. I really don't need to see why a picture of Mr. Barr when he's 33 years old has any relevance in what we're doing. You're going to hold it that. So that's what the only thing I can't do. I can't do your case. I can't tell you what you're going to do. But what I will do is not hold you to magic words. And I just love it. Mr. Gregory, still there?
Yeah, there he is.
Okay. Okay. You're muted. You're muted right now. Mr. Gregory, do me a favor. Can you hear me? Give me a thumbs
Yes,
up.
I can hear you.
Okay, there you go.
Yep, yep.
Okay, so Mr. Barr presents his case, then you get to present your case, same deal. You call your witnesses, you ask questions, they answer the questions. You can call yourself as a witness if you wanted to. If you're doing that, you can just give a narrative of what you want to do. I'm sure Mr. Barr will probably object during that time, but we'll make sure you get everything through on that you want. Or if you can, maybe you can't. Maybe Mr. Barr, maybe we sustain an objection by Mr. Barr on that. Any exhibits that you have, again, will be the same thing. You'll have to tell me about them. I'll have to make sure that they're legitimate. And you'll have to ask for them to be admitted into the evidence. When I do, Mr. Barrow will have the opportunity to object to it. He'll have to give a legal reason. You can tell me why we should have them in at that point. When your witnesses have gone through, Mr. Barrow can say cross-examines. I'll have the opportunity to ask any questions I have. You have what we can do, call a redirect. When you both do your sides of your case, I'll ask Mr. Barr if he has any rebuttal case that he wants to present. At that time, you can't bring anything new in, but if there's stuff that you brought into the case that he wants to rebut that wasn't there before, he'll have the opportunity to do that. Then what will happen is I'll say, okay, I'm all done, everybody. And I'll go away for about a month and I'll see if I might ask you to write something at the end to tell me what you think. I might not. But then I'll issue out a decision after that. I won't do it from the bench. So you got to wait for a little bit and we'll see what happens after that. Are any questions about that, the procedures?
I just have one question.
Sure.
Since I requested discovery 11 days ago, how much time should I wait before I request something to the court? Maybe he can be compelled to provide discovery to us so we can have time to go through everything and present it as an exhibit.
Mr. Gregory, I'm not going to tell Mr. Barr what to do, but I got a feeling I know what he's going to do. You should make that request again.
Okay.
I'm going to tell Mr. Barr he's got, we got a little time on this. I'll say that Mr. Barr has 2 weeks in which to, since you've given to him before, 2 weeks in order to get that discovery. He's going to probably file something and say he doesn't want to do that. Hopefully he doesn't. But
well, Your Honor, I already explained to I tried to explain to Mr. Grego that the discovery that was served on the 10th is not due until the 27th, because as it clearly states in my discovery requests and in the PUC rules, which he would like to read sometime perhaps, It's 10 business days, not 10 calendar days.
That's, as long as Mr. Barr gets it there, I don't care, just read that, make sure that it gets there in time. I'm not sure what dates we have on everything, that's why I'm, as far as when things have gotten to you and so forth, nor what your reaction is gonna be when you get it. Hopefully, Mr. Barr will get those over there. If you don't, tell me you got time, your stuff's not gonna be due till March. So, there's considerable amount of time in there. If that amount of time goes through, read the rules, you're representing yourself, so read the rules, make sure that it follows that. If it doesn't, and you're having problems, then file something and tell me. And we'll all get together and I'll probably tell Mr. Barr to, I'll probably tell Mr. Barr to get the discovery over if it's legitimate. If not, maybe Mr. Barr makes a good argument, maybe I won't. But we'll see after that, and I can't rule out anything till I see it in front of me. Okay? That all make sense?
Yes.
All right. Mr. Barr, you got anything more?
I think I'm good.
All right. Okay, thank you, gentlemen, both for being here again. And Mr. Grego, I know and I understand, having read what you put there, I realize that this is the third time that they've filed an extension. I can understand you're getting a little bit fed up with it. I understand that, but that doesn't mean you still can't make an agreement on anything again. You know, do this.
Right.
Just because we've gotten to the stage doesn't mean you can't. If you can find some way to make everything work, that's fine too. So don't foreclose that option as well.
Sounds good.
All right. Last chance, Mr. Barr, anything?
No, I think we covered it.
Okay. I guess I'll get a decision out on the notice to the motion dismiss and the procedural schedule, probably in the same thing. I don't want to, I can issue out together. I will.
Actually, to make it clear, there was a request to dismiss filed by Mr. Grego on Pikes Peak's behalf, and then we filed a motion to strike. So there's all opposing motions, and we also filed an alternative response to the motion to dismiss. So just to make that clear for the record.
Well, and you also filed for attorney's fees too. But and so whatever I think I'm going to treat. I can tell you right now. Again, I haven't decided yet. I think I'm going to treat the request as a motion to dismiss, and I'll probably treat yours as a response. That's what I'm assuming I'm going to do.
Okay.
But and then I'll rule on all that all together with the procedural schedule. So look for that. Normally, I say the procedural schedule will get out in less than a week, but with that, I got a couple other things that are pending right now. I got to get out to, so it might be a week and a half or so, but 2 weeks. So, all right, Mr. Grego, you got any questions? Everything makes sense?
No more questions. Sounds good.
All righty. Okay, thank you both for being here today. Appreciate that. And
thank you, Your Honor.
All right, nothing more. We shall be adjourned. Thank you.
Have a good day.
You too.
Thank you.